In this episode, I sit down and talk to Phillip Russell, an OSHA attorney, and this attorney works for businesses, not for OSHA. So Phillip and I get into a really good conversation, and he shares with us 3 OSHA law tips that you either don't know or misunderstand, or what he commonly finds among his clients. So he shares that information with us, which is incredible. We get to talk to an actual attorney to give us some insight into the legal aspect of dealing with OSHA. So let's get into it. Before we get into today's topic, I want to remind everybody, if your business is reopening after any kind of closure due to COVID, or you've continued to remain open, but you're struggling with how to mark your facilities to ensure physical distancing and relay important information about safety and health as it relates to COVID, I want you to go visit our friends over at Mighty Line Floor Tape. Mighty Line has some great products for you to mark your floors, whether it be the stand here, the 6 feet distancing, or just floor tape to denote lanes of travel. They have everything you need to mark your facilities. So hit the link in the show notes. Visit our friends at Mighty Line Floor Tape. They are incredible partners in safety. I can't thank them enough for their support of the podcast. Again, Mighty Line Tape for all of your floor marking needs. All right, we're here with Phillip Russell. Phillip, we've been talking for a while off and on. We connected on LinkedIn, and I really enjoy your legal posts because that's sort of what you do. So I'll let you introduce yourself, your background, how long you've been doing it, and then I'll get into why we're having a discussion today.
All right, thanks, Blaine. Good to be here, and happy to chat and meet with you, and I guess in person as we do these days.
Yeah.
So I'm an OSHA attorney, and so what that means is that I don't actually work for OSHA. What I mean by an OSHA attorney is I represent employers. So I represent the business when OSHA has shown up, either because tragedy has struck or there's been a complaint and there's going to be an inspection. Possibly a citation's already been issued by the agency, whether it's Fed OSHA or one of the state plans. But my job is to come in and to work with the company, represent them. And as you've seen me on LinkedIn, I used to say that I fight OSHA for employers, but I really don't say that anymore because I don't think it's accurate. I think what I do is I help employers hold OSHA accountable to the law. And that's what I think we're going to talk about today. But I'm with the firm Ogletree Deakins. We're a national labor and employment law firm. We actually are global. We've got some international offices. All we do is represent employers, businesses when it comes to employment matters. My specialty is workplace safety and health. I've handled the Tampa office for OSHA a few years ago started calling me the Grim Reaper because I had handled so many fatality cases. Yeah, the name stuck apparently, but I've handled so many fatality cases. My last count was somewhere between 150 and 175.
Wow.
So unfortunately, it's tough. But I'll tell you, I feel really, blessed and honored to get an opportunity to sometimes come in and help folks in the middle of real just human tragedy to sort things out. And that's why I said I don't really think it's a fight. I think it's just, look, we're going to hold the government accountable to what they're doing. We're going to hold them accountable to the law. They can hold us accountable too. And somewhere in the middle there, we'll figure out what happened and what needs to happen going forward.
Nice. I like how you put that. And yeah, I really enjoyed the synopsis of the OSHA ETS, that whole leading up to the final decision from the Supreme Court, and just kind of explaining just the legal side, because everyone has an opinion, and not that opinions changed much after that, but I was more interested in, just because I'm a nerd, like just the limitations of certain powers, and like just what OSHA can and can't do. I'm really into that kind of stuff. So I started reading your posts, and they're pretty insightful, and I started following you, and we kind of connected a little while after that, and I'm like, man, I gotta talk to you about some of this stuff. So what you're going to talk to us about today are 3 OSHA law tips from a veteran OSHA attorney, which is fitting because that happens to be you. So what's the first tip that you want to lay on us?
So, before I do that, I just want to say thank you for following my ETS posts.
Yeah.
I was more surprised than anybody that folks found my commentary to be insightful, because I will tell you, all I was doing was what I was doing already every day with clients every single day.
Yeah.
I guess it was the difference was the platform, right?
Yeah.
The forum, because I speak a lot. I'll probably cover 20 different conferences and seminars this year alone. And that's a usual year for me, but I will not, in those total 20, ever reach the kind of audience that I reach on LinkedIn, which is why I try to go there regularly to share some of these things with folks. And I'm thrilled to be on your podcast, Blaine, because I think the number one challenge employers face is not knowing what their rights are as employers and not knowing what OSHA can and can't do.
Right.
And so that's where the law comes in. And so really, and I've got some great friends that work at OSHA in DC, in the national office, in the regional offices, and in the local offices, and they really are good men and women that try hard. But there's one thing they don't have to do, and I'll get to our three in just a minute. But this is
Go
important
ahead.
important to set the stage. So you've seen all the crime dramas, right? Law and Order and all the crime. There's always a crime drama on. And when the police go to arrest someone, they do what? They read the Miranda rights.
Yeah.
Yeah. You've got a right to remain silent. Anything you say can and will be used against you in a court of law. Have you ever heard an OSHA compliance officer say that?
Not once that I've encountered them. No.
Yeah, no, because they don't have to, because that Miranda decision from the Supreme Court that talks about law enforcement having to read you your rights doesn't apply to OSHA, because OSHA is a compliance agency. And yes, it enforces law, but it's not a law enforcement agency that can throw you in jail immediately like the police can. And so that's why it's so very important for employers to know where the legal lines are, because you need to know how to hold OSHA accountable, and you need to know what rights you can assert as an employer. That flows from the OSHA Act in 1970, the statute that created OSHA and another agency, which we'll talk about. And it also comes from the Constitution. The Fourth Amendment, unreasonable search and seizure, comes into play. And then you also have to look at the standards and procedures that OSHA has. So there is a body of law that governs this agency. Final comment before we get to our three is watch the Supreme Court closely, because it's not if you're a safety practitioner, then you should be very interested in the Supreme Court right now, because they are issuing decisions that may not have the letters OSHA in them, but they are impacted. So the most recent decision, the one on the EPA, was similar to the ETS decision, Blaine, because it essentially reined in another executive agency that the court believed was acting outside the authority in the statute. Well, does that sound familiar?
Yeah.
That's
well,
exactly.
That case was interesting because the difference between the ETS and the EPA case was that the Supreme Court went as far as to say, they didn't say the EPA doesn't have the authority to issue, in this case, carbon emission caps, and that would impact an entire all of industry across the US, but they said Congress hasn't given it to you, right?
That's right.
And that's about, I don't know if you want to call it enumerated powers. I don't know what the term is, but like it's like, you can't just arbitrarily, well, it's dependent. I've got a phone and I've got a pen. With the administration or any administration saying, well, if you won't pass a law, I've got a phone and I've got a pen. I don't know. Was that Obama that coined that phrase? I think. We should be concerned with any administration who just says, I don't care about the legislative branch. I'll just make it happen. I'll just administratively do it. And so the Supreme Court, which is interesting you bring that up, and that's how I've been paying attention to it, the Supreme Court isn't making decisions, legal decisions. They're not making law. That never was supposed to be the point of the court, the judicial branch. What they're saying is, well, this is not the appropriate body to make that decision. Same with the ETS. They didn't say it didn't make sense to have vaccine mandates, or it was limited to this. The Occupational Safety Health Administration deals with workplace hazards arising out of the workplace. That this is a public health issue. There are other bodies, or you can go to Congress and they can do their thing and grant you that authority, but that hasn't happened.
That's and let me bring that down to in the field safety professional everyday life. Here's why that matters. So a few years ago, I think it's been about 3 years ago now, we tried a case against OSHA when OSHA tried to enforce a specific standard under the HAZWOPER standard. It was an ammonia emission case at a power plant here in Tampa, and it's all public record. I'm not sharing client secrets here, but OSHA had cited the plant for an emergency release of ammonia. And what's important is that we argued in the defense of the case at trial that the standard just didn't apply because there was no emergency release. The release was in the ordinary course of business, and hey, the system did what it was supposed to do. Well, OSHA didn't like that. They lost at trial. So we took it up to the review commission. Well, they lost there. So OSHA didn't like that. They took it to the 11th Circuit, and they didn't like that the 11th Circuit just affirmed again. But what's important, though, is that every step, whether it was the judge, the review commission, or the 11th Circuit judges that reviewed the case, they held to the language of the standard. And that's why it's important to safety professionals now, because the ultimate decision maker about who decides if OSHA got it right or not is the Supreme Court, because OSHA cases do make their way to the Supreme Court. And what we know is that there are at least 5 justices right now that are going to look at the exact language and hold OSHA to the language, not what it is, not what they think it should be. So I think that's very important to watch the court.
Man, my first introduction as a young practitioner many years ago was a citation, construction company I worked for. And I went along with the compliance officer. They took a photo of something. I'm like, I don't even know what they took a photo of. So I took a photo and we kept walking, right? Turns out we get a citation. It was a propane tank that was being used to heat up water for mortar mix on the job site. And it had a fabricated bottom on it, like a stand, and it was set there. And the citation said it wasn't secured in an upright because it wasn't chained, was it? And I said, well, it was in use. It doesn't need to, and the standard was clear. And so we came prepared. We're like, hey, we got this. The area director slid the photo across the table, didn't even look at us, and said, does that look safe to you? And I looked at our company attorney, and I just kind of shrugged, and he shook his head, and he said, no, he says that meets the standard. And that was it's subtle, but if you're not paying attention, that can get you, right? Whether something looks safe and whether it meets the standard are two different things. OSHA can't just arbitrarily apply what they think is safe if it's not been codified, if it's not actually a standard, right?
Yeah, and Blaine, that's where there's a difference between safety and compliance.
Correct.
And I know your audience is going to really, I think this should resonate with them, because safety, as I've been told by many clients, has nothing to do with compliance.
Nope.
Now, it has something to do with it, but I get the point. The point is, and look, I'll quote one of my clients. We had a fatality a few years ago, and right afterwards, the executive, the CEO gathers everybody in a conference room. I was there, and we were talking about what are some corrective actions we need to implement to make sure that this kind of fatality, this thing never happens again. Always a great discussion, happens with every one of my clients. If you're not willing to do that, you're not a good fit for me. I'm not your lawyer. But we had this meeting, and the client, I remember him slamming when someone said, "What are we going to do?" And I referred to an OSHA standard, and I remember his name's Mike. Mike slams his fist on the table and says, "I don't give a damn what OSHA says." Now, if you heard him say that without the story or without knowing Mike, you would think he's ignoring OSHA.
Right.
And he wasn't. But what he was saying, that's the floor.
Yes.
And that's where, and safety is oftentimes above that. But when OSHA comes, here's the distinction. When OSHA comes knocking, claiming you violated a specific standard, no, Now it counts. Now the words matter. That's why we're looking at the standard. And that's what I mean by holding the agency accountable. And so
Absolutely.
that's a good segue probably to our kind of our first of our 3 points I wanted to make with the audience today. So should I jump in?
Yeah, let's just get right into it.
So first point I want to make is this, is that OSHA citations are not final. Now they look that way. When you look at that package, when I first started practicing OSHA law, 12 years ago or so, and by the way, I've been an employment lawyer for 27, but 12 of those years has been almost all in OSHA law. But when I looked at that at first, I thought, wow, this looks pretty final. There's a payment coupon. There's a convenient web page you can go pay. They talk about their collections team or something like that. There's a penalty dollar figure. There are abatement dates that are coming up soon. And the government just told me I got to do something by a certain date. I'm a little worried here. And I'm thinking that, wait a minute, this is the government's findings or conclusions. And then I've learned it's none of that. A citation from OSHA is an accusation. It is an allegation. And that is the government saying, we think that you violated a specific standard or the general duty clause, as the case may be, but we think that there is a violation here. And by the way, I'm not saying that you should disregard these things. Altogether different point here, but you need to understand that it's just the OSHA, it's just the government's side. It's just that it's really similar to a complaint filed in court. A complaint is not the end of a case in a lawsuit, it's the beginning.
Yeah.
And so in many ways, a citation is not the end. It could very well be the beginning of a long fight with OSHA. So I just think that it's very important to make sure that employers know that and make sure you know how to analyze those things. There are various moving parts here, Blaine. It's the number of items, it's the classification of those items. The narrative, by the way, a lot of people don't know you can negotiate changes in that alleged violation description. It's not set in stone. You can negotiate changes or modifications to that language. We do it all the time. Did it this morning on a case.
Yeah.
And there's proposed penalties, there's abatement, which, by the way, you know what I've never, in hundreds of cases, I've never thought about? Penalties.
Yeah.
Just never the issue. It's usually the impact on safety, impact on operations, and impact on the business. It's almost never about the penalties. Some say that means maybe the penalty should be higher, maybe not. I don't know. We'll see. But I just want to say that, when you're looking at that, almost nobody ever goes and say how much money we got to pay. It's usually about how is this going to impact what we do and whether or not we can continue to be safe and do our business.
And so you're right. I think that when you get that certified mail, that starts a process. And usually it's the informal conference to gain some of that clarification. But so what employers need to understand is that even if you're requesting an informal conference, that clock is still ticking. Is that correct? There's an expiration date on this process that you have to understand.
Yeah, and when you receive that citation, and here's the key, when the employer receives a citation, now that doesn't matter who receives it. If anybody at the employer signs that little green card saying, I've got it, or even arguably if someone receives it by email, there's some reasons why that may not work, but once it's received by the employer, a 15 working day shot clock has started. Do not miss that deadline. There are little to no excuses that will ever allow you to get around missing that deadline. Don't call me and ask me to do it because it's really hard. Excusable neglect is what lawyers like to argue. The courts have roundly criticized that argument. So you really have to be prepared. If there's been an inspection and something, is likely to be coming, one of the first things you need to do, even as far back, Blaine, as the opening conference, is make sure the compliance officer has identified the right employer and has the right contact person and a backup, because people change jobs.
Yeah.
Because that way you want to make sure that you get it. And once you do receive it, calendar those 15 working days. Don't count weekends or federal holidays, but you have to have that informal. And I don't know that I've ever recommended a client skip the informal. Always go.
Yeah.
Even if you don't think you can even if you don't think you can resolve it, always go. There's always a relationship to be built and maintained with OSHA, even if you disagree.
Oh yeah, I talk to safety professionals even that underestimate the good faith, that show of good faith, just going to the informal. And yeah, even if you with legal counsel go fully prepared to accept what was alleged, there are always opportunities for them to not that it is about the money, but especially if it's a training issue, or something like that, or if you will conduct certain training, that they can reduce the penalty amount by up to 50%. The area director could do that if you agree to some sort of settlement agreement, right? That as long as it's something that you agree to. But that was a great tip with the opening conference of making sure that you verify the company name, they've got the right company, and then they have the right POCs, because you may not get certified mail, if at all, for up to how many months do they have to issue a
6
citation?
months.
6 months.
6
So
months.
we're talking, let's say it's 4.5, 5 months from the inspection. How many projects or how many working days have passed? How many issues have come up since then? Our memories are not that great, right? So that was a good
Well,
tip.
in the 6 month thing, let's make sure we understand that. That sometimes is also a misunderstanding. The 6 month shot clock for OSHA does not start when OSHA shows up and starts their inspection. It starts on the date of the alleged violation. That's right out of the OSHA Act, right out of the statute. Sometimes OSHA I've seen try to argue, no, it doesn't start until we get there and open up. No, that's not what the law says. Again, holding them accountable, right?
Yeah. So the alleged violation could have been a week and a half ago, and they're
Hmm.
responding to something. So they've already burned a week and a half off of their clock.
That's
Tech.
right. The only
Good.
the only way that date stays the same is if there's a continuing violation on the date they're there. But if
Right.
it was a discrete accident or incident and that's what they're inspecting, then it started on the date of the accident. That's when the 6 month shot clock starts.
That's good to know. That's good to know. What about the next tip, the second tip you have for us?
So second one is this, and this is one that may seem a little bit familiar to safety pros, but it's this general duty under the law that employers have to have a workplace free from recognized hazards. And yep, that's Section 5A1 of the Act, and also known as the General Duty Clause. The reason why that's important is it's always been there, but it was intended really sort of to be the secondary consideration for the agency when it came to enforcement. But lately, we've seen with several issues that it really becomes more primary.
Yeah.
And when OSHA doesn't have a specific standard, yet they want to do something about a hazard they've perceived in the workplace, then they're going right to 5A1. And we don't have to look further than COVID to give you an example.
Yes.
No specific standard on communicable. All right, say a big word for me. Diseases in the workplace. Goodness, airborne pathogens is what I was trying to say.
Yeah.
No specific standard, although hey, they're working on one. We know they are, but no specific standard yet. So they use general duty. Same
And
thing with workplace violence. For
right.
years they've wanted to have it. So, there's no rule and there's no OSHA standard that says you have to keep your employees from beating each other up. But I'm saying that a little bit tongue in cheek. I don't mean to make
Sure.
fun. Those are very serious situations, but there's no rule that says anything about that.
Hmm.
So OSHA has to use the general duty for violations. And look, I've seen some very, very nasty cases, especially in healthcare, where you've had mental health patients who have been violent with the employees, and the employer was doing nothing. And kind of the secret there is to 5A1 is do something, not nothing,
Right.
because OSHA doesn't have the legal authority to tell you exactly what to do. But if it does offer up a list of things to do, consider them. So
Yeah.
right now, I hate to do this to you, Blaine, but hot topic: heat illness. Yeah,
Yeah.
sorry, I drop
That
that one
was
all the
that
time.
was a hot pun right there.
Yeah, sorry, it's just too easy. So the hot topic of heat illness right now, OSHA wants to make a standard. They want to issue a standard. They've issued their advanced notice of proposed rulemaking, so they're going to have a standard. But before we get to that point, they have issued a national emphasis program back in April that says, here's a list of things we think employers could do to abate the effects of a hot work environment, whether it's indoor or outdoor. And so the advice to employers and safety professionals is look at the list, do something. You may not necessarily have to do them all. The hardest one to comply with is acclimatization because nobody knows exactly what that means and it deals with individual medical issues and physiologies. But do something, rest breaks, shade, water, hydration, changing up work hours if you can. Look at the complete range of things and do something, not nothing. And that's the way to kind of avoid liability for not dealing with a recognized hazard that could cause death or serious physical harm, which is what we're talking about in general duty.
Yeah, and what's funny, we have in healthcare now the workplace violence training requirement, and some other things they have to comply with, but it's very specific to the healthcare industry. Ergonomics is another good example where we don't have a uniform, approach to musculoskeletal disorders, so that's still cited under general duty. Workplace violence is interesting to me because of the nature of the hazard. In every other case, not every other case, most other cases, it is something that arises out of the course and scope of the work processes, the materials, the machines, the tools, that. When the general duty clause, when I read it literally, and this is probably where I get myself into trouble. And that is, and you're going to help pull me out of the pit here. The employer has a general duty to provide a workplace free of recognized hazards that are causing or are likely to cause death or serious physical harm. How can the employer do that when it comes to a bad actor outside, like in retail, a retail store, and a bad actor comes in? We've been talking in our Safety Pro podcast community site, we've been talking about these flash mobs recently of going in and doing smash and grabs, like 40, 50 people at a time show up with masks and run through Dillard's or, these other department stores and just grab stuff. And if they push somebody over and that worker is injured and OSHA comes in and they're like, well, you didn't do, you didn't do workplace violence training. And it's like, well, how does the employer fulfill the duty to provide a workplace free of? God, you show me a workplace that's free, devoid of any hazards. How does that, that's vague, right? I mean, how do you handle that?
Yeah, you sound like Mike Rowe. I don't know if you've heard him give his talk, but he gives a great speech on safety third, is what he calls it.
I've seen that
episode.
Yeah.
Yeah, it's brilliant, and I saw him do a live presentation on it earlier this year, and he makes the point that to the extent an employer tries to occupy the space entirely to make sure there's no hazards in the workplace, then it has a psychological impact on employees of wanting to take less care of themselves, and that one of the messaging issues that he thinks employers and individual workers need to change is that I've got responsibility for my own safety. There are things I can do. So that's one thought I had. But this whole idea of a recognized hazard, let's unpackage that real quick on the workplace violence. OSHA takes a position that workplace violence is a recognized hazard, but it doesn't say in all work environments and in all employers. And that's really the key, because you can take a generalized society threat and say that's a recognized hazard. Well, that's not what the law says. Recognized hazard is something that is specific to the industry, to the workplace, or to this particular employer. And so here's the difference. If you are in the middle of, if your store is, in a one red light town in the middle of, one of the flyover states, pick one, I hate to use that term, but you get the point.
Nowhere, right?
There you go. And it's, and there's an unforeseen violent thing that happens, no, OSHA's, I doubt, going to take an issue there. But if you are in an area where there have been riots, there have been looting, there have been violence targeted to your specific store or stores down the street or in your city, and you've done nothing by way of security and training and feasible, and there's the key word, Blaine, feasible means of abating that hazard, that's when you might have OSHA come knocking on the door.
And that's where it gets back to that, the probably the most useful tip of all, which is do something, even if it's awareness training. Like, hey, these are things you could do, like get out of the way, go to the back of the store, leave the building, forget the items and the merchandise. We're insured, don't. But it's interesting because, Starbucks just announced they're closing 16. They're starting with 16 stores in cities because of crime and drug use, in going on in their bathrooms, and assaults on their workers. And there's more to come. The CEO just said there's more coming. So that's a bold stance. Well, we're just going to pull out completely of some of these areas because workers have said they don't feel safe. And that's a good example of doing something, the extreme example of doing something, which is, all right, we're not going to operate there. That's tough for workers and the customers.
Yeah, that's impacting people's jobs. And livelihood. So that's sad to hear.
Yeah. So what's the next tip you have for us?
So this is one, have you ever heard, Blaine, anyone say like, well, I don't want to get a lawyer, because I got this citation or OSHA's doing an inspection. We don't have anything to hide. So, we're just not going to hire a lawyer to help us with this inspection or with OSHA. Have you ever heard that before?
I have heard worse. I have heard an owner of a business say to me, that's why we hired you. And I'm like, no, I'm not a lawyer. So my advice to you is to hire a lawyer for this. Yes.
Well, here's why I bring that up, because I've heard that before too, of course. And what folks that say that, they misunderstand, I think, a few things. And so let's set the record straight. So one, OSHA already has its own law firm. It is the United States Department of Labor Office of the Solicitor. We just call them the solicitors. That's the lawyers. That's the internal law firm for the Department of Labor. They are a sister agency to OSHA. So the Department of Labor has various agencies. You got the Wage and Hour Office, you got OSHA, you got others. And one of them is the solicitor's office. That's the law firm, internal law firm that represents the agency. And they're there helping them when tragedy strikes. They may not be on site, but they are accessible, and they're all organized. The solicitor's offices are organized in regions around the country. So not every OSHA area office has a lawyer, but every OSHA office has a lawyer that they can call. And for example, here in Tampa, in Florida, the area office here, they report to Region 4 in Atlanta, and they've got a head solicitor up there, and she has a team of lawyers. And the compliance officers, the assistant area directors, the ADs, all have access to them on a call me now basis, and they do. And I have been on job sites before when the compliance officer was on the phone with the solicitor's office. And so if OSHA's already starting off with their own law firm during the inspection right after tragedy strikes, then why would you as an employer not want someone advising you on your rights? Because remember what I said at the beginning, they don't have to tell you your rights.
Correct.
It is up to you to know them.
That's crazy. So that's what you're up against, right? And if it's a serious issue, stakes are high, either the number of violations, the category, and yes, the penalty amount, the proposed penalty amount. You better get that's my advice. Get representation, because
but here's the thing. The question is, when do you get exactly but here's the question, when? Because what you just used the example of, Blaine, is maybe after a citation has been issued. My advice is don't wait, because OSHA doesn't wait to call the solicitors when they issue a citation. They call them in advance. They call them, especially in fatality cases, catastrophic cases, and especially, Blaine, if they're on the news, because now you got politicians calling the agency saying, what are you doing about this? And so, certainly in those higher profile, fatality cases, catastrophic cases, I've handled multiple cases where there were multiple fatalities that happened at once. Those are ones that I know the solicitor's on the job day one. In fact, I routinely ask the compliance officer, hey, what solicitor are you working with on this case? Because I might know them. And if so, then we're going to start having some early conversations about what legal issues may be coming up.
Wow.
And I say all these things, Blaine, I really do. I mean, I hope these three things are helpful to the audience, but I don't say any of these to help any employer get away with anything.
Right.
That's not the purpose of a good OSHA lawyer. A good OSHA lawyer, and I'll tell you the difference because OSHA once told me the difference. They actually appreciate the agency, and this is coming from some high ups, and I'm not going to tell names, but high ups in OSHA at all levels, office level, region level, and DC, that they actually appreciate when an experienced OSHA lawyer gets involved, because they know that lawyer will be able to educate their client on where the law is and what can and can't be done by both the employer and the agency. They get frustrated, however, when an employer shows up with somebody that does this, has never done it before, doesn't know the OSHA Act, doesn't know how the law works, and they're winging it, or they're one-offing it. They're a construction lawyer or an employment lawyer, or I've even seen family lawyers, that have shown up. So that's the cautionary tale to folks is make sure you get, I mean, it sounds a little self-serving. Yes, I know, because I'm an employment lawyer, but or an OSHA lawyer, but get somebody who's done this. It's like, I'll finish this on this note, Blaine. I went recently to go have my Achilles heel looked at. So I go to this orthopedic, and I'm sitting in there. I was like, hey, while I'm here, doc, my shoulder's hurting a little bit too. You're an orthopedic. Can you just take a look at my shoulder? And he laughed, and he said, no, I'm not a shoulder guy. And I laughed back, and I'm like, well, that's what I tell people. I'm an OSHA guy. I don't do immigration work or whatever. So, everybody's an expert and specialist these days, especially in a high profile fatality case. Don't wing it, and make sure your lawyer's done this hundreds of times, not a handful.
Wow, that's great stuff. I mean, my head's spinning now. I'm having flashbacks to, unfortunately, the 5 fatalities that I've been involved with. Not the experience you've had, of course, but none of that's good experience in my opinion. It's just terrible, every one of them. But yeah, the last one, I had such a, how do I want to phrase this? I would say an unexpected experience with OSHA. They really felt like they were partners in getting through that process. I almost hesitate to say it. I got close with the compliance officer that led the investigation. I'm familiar with him now. I still talk to him from time to time. On a professional level, I didn't get to know him personally, but yeah, it was the way he handled the interviews. I mean, it is a tragic time for the company and the families and those involved and the workers that were there, and the way watching him handle that and approach the employees and even the manager at the time and the VP of the company, and even with our attorney, and it was just top notch. It was nothing but professional and empathetic. I mean, he felt for what everyone was going through. And that right there, it just really took a lot of the edge off, if you could even possibly do that in those cases. And my experience with OSHA was nothing but good in that case. So they go through a lot of training for this, and that doesn't mean they're all like that. Just like you said, there are attorneys that don't pay attention to this stuff. But I gotta say, I'm glad we had that experience with OSHA, because it could have been a lot worse, so awesome. So Phillip, where can people go to connect with you? We mentioned LinkedIn earlier, but they can just find you on LinkedIn and connect with you if they want to connect.
Yeah, LinkedIn is I'm easy to find. I don't hide. So Phillip Russell on LinkedIn, or OSHA lawyer. My firm bio for Ogletree is at ogletree.com. I don't remember the exact details of it, but I actually update the LinkedIn bio more regularly.
Okay.
So I just send folks to LinkedIn and email. I don't mind an email from time to time either. It's Phillip, PHILLIP .Russell, RUSSELL, at ogletree.com, and that's OGLETREE.com.
Awesome. And I'll have links in the show notes to your LinkedIn profile and ogletree.com as well for anybody who's looking for, well, if unfortunately, if you're looking for representation, but there are other service. So that's another good point. Before you leave, let me pick your brain. I know this is somewhat off topic and I've thrown a lot at you. So mostly because I see a squirrel and I go for it. But what's the value of having, I don't know if you want to say on retainer, but like having, like, not waiting until you need someone to go and look for somebody who could possibly help in these types of situations. Don't you think it's a good idea for an organization to already have talked to somebody, even in the off chance we may need to reach out to you? Like, isn't that a good idea?
Yeah, one of the things you could probably tell from this talk today how passionate I get about this issue, and that is the issue of helping workers stay safe. Absolutely is the lead. I don't talk about this very often, a little bit more lately, but my mother was killed in a workplace accident. So,
Oh no.
yeah, we weren't close at the time, and it's not why I'm an OSHA lawyer, but it impacts how I practice as an OSHA lawyer. And so it's very important to me. But I get really excited about working with companies and helping them understand what they can and can't do and what OSHA can and can't do. And even just today, Blaine, I had two clients of mine that are national clients, operations all over the place, that we are going to implement this fall a more robust training program for their facility managers. Both of them are manufacturers. And that they want us to put together a training program for their facilities folks on what to do if OSHA shows up.
Yeah.
Because the safety folks like you are well trained, the VP of EHS, your safety directors, maybe even sometimes your regional safety, they all know what to do, but they're not always there. And so sometimes an employer, you either say you're not allowed to come on here, government, and they put up a big wall, which is not the approach, or they roll out the red carpet and say, welcome, do whatever you want. And it's somewhere in between those two. And so I think that really it's the training is the piece. And we do a lot of this. I've got most of my clients are probably, or they are in construction, but these two just happen to be in manufacturing. But there are a lot of construction clients for which I do this regular, ongoing, recurring training, reminding folks of what to do if OSHA shows up. Actually, you know what? For your show notes, I'll send you a generic what to do if OSHA shows up flyer. It's kind of a starting point I use with clients, which is they can take it, customize it, and add in things. But you really need to make sure, the big thing here is to make sure that folks, especially at remote workplaces, what do you do whenever you have a compliance officer that just showed up? Based on a complaint, they're here to do an inspection and you had no idea they were coming. What do you do? So that really is the answer to the question. We do a lot of that kind of training. I think it's very important.
Perfect. There you go, folks. Connect with somebody now. Don't wait until later. And by the way, Phillip, and I said this at the beginning, but we connected organically. This is not, there is no affiliation whatsoever between the podcast and Ogletree or Phillip. This is just two pros having a conversation. That's how we connected, and that's how it should be. That's the way I like it. So, and I would ask the audience, the listeners and the viewers, to head over to the Safety Pro Podcast community site, because Phillip is going to give us two more tips, legal tips. I want to say tips, OSHA law tips for our premium members over at the community. And we'll get into that here in a moment. But Phillip, I can't thank you enough for taking time out of your busy schedule to talk to us on the podcast.
Thank you, Blaine. It was a pleasure. Always enjoy it, and look forward to continuing the discussion.
Absolutely.
All right, there you go. Phillip Russell, OSHA attorney. Thank you so much, Phillip, for sharing that insight with us. And as mentioned, if you are a premium member over at the Safety Pro Podcast community site, you will get 2 additional OSHA law tips from Phillip, as well as what to do when OSHA's at your door, a checklist compiled by Mr. Phillip Russell himself to help you prepare your site leaders. And that's important too, because, we kind of touched on that, but we've got to prepare our site leaders, those who are likely to encounter OSHA when they show up. They've got to be prepared on what to do, what not to do, and all that good stuff. So that checklist is available to premium members as well. If you haven't been to the community site, take a peek over there, see what's going on. We got some really cool stuff happening. over at the community site, and I will talk to you on the next Safety Pro podcast.